take strong exception to
I'll withdraw that statement,
that
Chair.
kind of language.
I'll
Thank you.
withdraw that statement.
Thank you. Thank you. What you've said raises two issues. What
Yes,
you
Chair,
have
I'm
said, what you have submitted raises two issues. The first one is you asked the Commission to keep all documents, affidavits and all relating to this matter confidential. The first issue is, I have no idea why Mr. Karim would not have wanted to file his statement if, in the face of his request, and there being no basis for him to believe that the statement would not be kept confidential. That's the first problem I have. And then secondly, my point about there having been no change with regard to the deadline, yes, I've heard what you say, but the bottom line is the deadline was never changed. The deadline stood. So on those 2 points, I still have difficulties with your submissions.
Chair, I don't know if you want me to respond or
Yes,
those were
you're
your
free to.
concluding
Yes.
remarks.
No. You're free to respond.
No, thank you, Chair. I
Mr.
appreciate
President.
that.
Yes.
On the first issue about not be kept confidential, I'm not going to rehearse what I said. All I'm going to point out, Chair, is the first time that that was given unequivocally, that the main statement would not be disclosed prior to the determination of the in-camera, was only finally clarified on the 3rd when the directive came out. That was on the facts after the statement fell due.
Just on that, why right from the beginning, instead of tying the filing of that statement to the hearing of the interlocutory application, why did the applicant, in the first place, not make the simple request that that statement should be kept confidential?
But with all due respect, we did, and that's addressed, that's in the founding affidavit and the notice of motion, and it's in the covering letter. And that's part of the difficulty we have here, is that we place all of this in front of the Commission, we ask for an expedited decision and an outcome, and instead of being told or being told by the Commission, yes, your concern about the main statement is taken care of, it will be held in confidentiality until such time that the in-camera is determined, we don't hear anything. The first time that the Commission puts up an answer is on the 24th, and incidentally, it doesn't deal with the request regarding the in-camera. If the Commission was able to give that undertaking by the 24th when it filed the answering affidavit, then we wouldn't be having this debate, because by the 27th, my client would have filed the statement.
All 15 pages of it, yes.
Yes, absolutely. Whether it's 15 pages, 3 pages,
I know,
100 pages.
I'm just, yeah.
Whatever the case might be, he would have been able to file because the undertaking would have been given. The only time that my client then was given the assurance is when the 3rd comes down, the 3rd directive comes down. And look at what happens. When the directive comes on the 3rd, and the directive says, you must file your statement by the 4th, and you must file it by 9 o'clock, and it will be kept confidential, the statement is filed, no difficulty. So with all due respect, it's a bit unfortunate that my client finds himself in this position in circumstances where he's not in control of these things, and a concern is raised for determination that affects the filing of the statement but is being dealt with in the way that I've just explained. So that's on the first issue regarding the main statement. The second issue, Chair, which I've now forgotten because I've written a note here that says deadline, but I have no idea what that means.
I think I've forgotten also, but probably...
As long as you forgot, Chair, that's fine. That's okay for me.
Probably it was that. But the bottom line is that the deadline was never changed.
Yes.
Whatever may have been going on in Mr. Karim's mind, the bottom line is that the deadline was never changed.
But that's it. But you see, that's, with all due respect, it's that catch-22 dilemma that my client is caught in.
Do you know what judges usually say? They say that when counsel says, with all due respect, deep down inside they're saying, what the hell?
Chair, I've never been accused of using such soft language in my entire life, so I'll take that. I'll take that.
Mr. Karim, you wanted me to reformulate my question, rather to
yes.
re-put it to you. I thought you had answered my question, but then you went on to muddy it with the threats and the filing of the statement, and all of that was said about it. But I had, the first part of your response was, you are not saying that there's been a disclosure of information submitted to the commission by Mr. Karim, which he had marked to be confidential. You are not saying the commission has landed that kind of material in the public domain.
Yes, we're not saying that.
Yeah, that's what I wanted to clarify with you. And then my next question, which I may well now ask, it's now out through you, right, in the engagement with the chair, why you want this application to be in camera. We've had many slip-ups like that from legal representatives, where they do seek something and then they are the ones that actually disclose that which they're asking for.
Yep.
Or that they're arguing. So it's now in the public domain, the reason that you want this application to be in camera. Is there still hasn't the issue become moot? At least this first part. Hasn't the issue become moot, and we should just go ahead and hear that part of the application?
Chair, my attorney is whispering something to Chair, through you. May I just take the instruction? Thank you. Thank you. Commissioner Baloy, before I forget your second question again, I'll still go back to the chair, but in response to you, Commissioner Baloy, yes. That's exactly why when I started, I said I have to place my concern on record that if we have this debate in the manner that it's happening, the very purpose of the in-camera would be rendered futile. And so when I started my remarks, that's why I needed to record that, because I was caught in a catch-22. Either I sit here silently and look at the three of you, and the three of you look at me, and I don't say anything, or I have to address what I need to address, but my claim for confidentiality and in camera is then materially prejudiced by that. And it's that very conduct, with due respect, that I'm saying has caused the prejudice that my client complains about in the affidavit itself. I mean, it's that famous Sutherland judgment, BDFM versus SAA, that once confidentiality is lost, it's difficult to get it back, and that's the exact position my client finds himself in. So I accept that it might have been through my own doing, but it was under the cover of recording the concern I had regarding the futility of us proceeding then in the way that we had.
I guess it may become necessary for us for completeness, to pronounce on your argument for confidentiality. It may well be, without changing anything, because as you seem to agree, the issue has become moot. We might as well go ahead with this application, but then the chair may have to pronounce on this claim for confidentiality, whether there was a case for it in the first place.
Yes, may I say, Commissioner Baloy, it's like one of those interlocutory disputes that arise in a main proceeding where the determination of the interlocutory then has the unforeseen consequences that it has. And given that as we walked in, we were then subject to live television cameras, that's the catch-22 that I was caught in, but also that my client was caught in. So even though the application is theoretically still in front of you, because as the chair reminds me, we're still only dealing with the preliminary point, I accept the consequences of the arguments that we've just had and we've just made. May I just go back, Chair, the second point that you had made, which we had both conveniently forgotten, but then unfortunately you remembered, about the deadline. I hear everything that the chair says. I would only ask that the chair bear in mind that there was a request for a ruling before that deadline came and went, so that my client would know what to do in circumstances where he says, I'm asserting a right of confidentiality. If I give my statement, that will render my asserted right of confidentiality nugatory, and on the other hand, if I don't give the Commission what they want, I am then liable to coercive force by the Commission in the enforcement of its rules. So, yes, the deadline is what it was, but it's not without the prior context of, please tell me what to do before that deadline comes so I know what my position is. Thank you, Chair. May I just check if there's, oh, I apologize, Commissioner Kumalo.
Mr. Permit, you could have just said, here is my statement, it's ready, please treat it confidentially. There was no need for all that drama. You wanted to consult with your attorney and then we will ask our questions after, so, yeah.
Thank you very much, Commissioner Kumalo, for the indulgence. We're ready to
I don't
proceed.
want us to debate the point I made because I think the preliminary point has become, I think you should just leave that prayer. Prayer 2 must just be abandoned. And when you deal with prayer 3 and 4, I will tell you what my concern is.
Before the merits, may I? Oh, did I get the impression that, but for our engagement, you were done with your submissions, Mr. Premier?
On the preliminary, yes, I think it's only fair that Ms. Hassan
Yeah,
gets an opportunity
that's where I want to go to.
respond.
That's where I want to go to.
Although
Are you accepting you abandoning 2 so that we don't need to debate?
I would prefer the Commission make a ruling against me rather than abandoning it.
Okay.
All right.
Thank you, Chair.
Ms. Hassim?
Thank you, Chair. I mean, in the light of the questions that came from the Commission, I can be brief just on the preliminary point. I think we should probably just get straight to the merits because, as Commissioner Baloy says, this issue of the preliminary point has become academic. After the first, I think it was only after the first minute or two of my learned friend's address, we strayed right into the merits. And so part of what's been debated in fact, concerns the merits of the application. But even though, that should be the end of it, I would like to say 1 or 2 other things. The first is that my learned friend says that he did not understand the session today to be a session in which it would be a public one. And I must say that's hard to understand in the light of the directive of this court on the 3rd of March.
Commission.
Pardon me, of the Commission. I must wear my other hat. In the light of the directive of this Commission on the 3rd of March, which stipulated that it would be heard in open session. Now, even if that were not a live broadcast, what it could not be understood as is to be a session that would be closed to the public. So even if it were not a television broadcast or live streaming on other platforms, this was going to be an open session, open to the public and open to the media. So any reporting or any coverage, photographs, anything would still be permitted in an open session. So it doesn't aid my learned friend to say that, understanding of what an open session was that it would be somehow closed and that it would only be perhaps the legal representatives and the commissioners. On the statement, let me say, the statement, it's always been the practice of the Commission, and there's never been a breach of confidentiality thus far, not in relation to this witness or in relation to any other witness on the side of the Commission staff or evidence leaders. So that is not something that ought to have given rise to some suspicion.
But on that, I can imagine that Mr. Premhid will probably say neither he is instructing attorney nor Mr. Karim knew that procedure.
That was, and let me say that there has been some clarification in that regard, that statements that are given, the practice is witnesses provide statements to the commission before they appear before the commission to provide their oral evidence. It's only once the witness testifies that the statement becomes public. So it would only be on the determination of this application, which would then determine what kind of procedure follows next, that the statement would become public. That's the second thing. The third thing I want to say is that in relation to the perceived threats of the breach of the ruling of this commission, it is important that witnesses understand, and the legal representatives, what the requirements are of the commission and the status of rulings that are given by the commission. So it wasn't in the nature of a threat. It was in order to advise the witness that you now are in breach of the ruling of the commission, and it's important, and a duty, I would add, of the evidence leaders to protect the processes and the integrity of the processes of the commission. So a ruling that says that the statement is to be provided on a certain date is that. It cannot be amended without the chair's reconsideration of the ruling, which would require an application, and there was none such application in that regard. And finally, on the statement, it really wasn't tied to the determination. It wasn't conditional on the outcome of the in-camera application, right? Because the statement is for the purposes of providing evidence to the commission. So I just wanted to make those remarks with regard to the statement to clarify that. But I've also said what I've had to say about the ruling on the 3rd of March, that this was to be an open session. For me, that's where this preliminary debate would end. And so, and then given that the ship has sailed, we should probably proceed into the merits of the application. Thank you, Chair.
Thank you, Ms. Hassim. Mr. Premhid, one last. Yes. Any response, Mr. Premhid?
Yes, three very brief ones, if I may. In respect of the first point made by my learned friend about her understanding of the directive, with all due respect, it's not her understanding that matters. It's what the commission makes of the application and the request for the ruling beforehand. And that's why the ruling was made beforehand. The request for the ruling was made beforehand, so my client wouldn't find himself in the exact position he finds himself in at the moment. On the second point, my learned friend, in fact, actually makes the case for us, because her exact words were, it's the determination of this application that would thereafter determine the disclosure of the main statement. And that's exactly why, not only in the correspondence and in the notice of motion, but in the founding affidavit, before that statement was due, the direct application was made at paginated page 12 of the pleadings bundle, paragraph 27, I humbly request that the commission determine this matter as one of urgency. This is because my witness statement is due on Friday, the 27th of February, 2026. If a determination is not made about my hearing evidence in camera, and with that regarding the witness statement, by this date, then my witness statement will be made available to the general public, defeating the purpose of this application. If that was wrong, they filed the answering affidavit on the 24th of February. They could have made the undertaking or given the clarity on the 24th of February that the statement wouldn't be disclosed.
But why would he have thought, and I think that's a point that Ms. Hassim was making, that his statement would be made public before he testified? On what basis does he have that concern to a point where he doesn't abide or comply with a clear directive?
But that's because, as the chairperson foreshadowed, is that my client doesn't have knowledge of the inner workings of the commission.
It's not about the inner workings. It's about what, you see, what he has done, and I have to deal with this by way of an example. He has made a claim. He's making a claim for confidentiality and for in-camera, based on the threats he has received, but matters that he says are reported in the public domain. He's made references and he's annexed stuff that is in the media. So he's relied on matter that is in the public domain. I'm asking a question like that there is nothing, he knows nothing about the processes of the commission, as you rightly say. He doesn't know our internal workings. But again, he has nothing from the public space that is a basis for that concern about his statement being made available to the public. He makes it up. He makes it up, and on the basis of that fear that he's making up, he then says, I'm not going to file my statement until you give a ruling, because it might go into the public, when there's absolutely no basis whatsoever, no factual basis for him to raise that kind of concern, and therefore not to abide a ruling that says you must file by a certain date. So it's not an answer to say, I guess what I'm doing is I'm saying, how reasonable is this fear about my statement will be disclosed to the public when there's absolutely no factual basis for it?
I accept that, and you've already heard me in my opening remarks that, to the extent that explanation is needed in the affidavit directly, it's not there, and I'm not going to push at that. Instead, what I will say, at the risk of repetition, is that that's the very reason why the ruling was asked for by the 25th, so that he wouldn't be in the position of potential non-compliance, because that clarity, and on the basis that Commissioner Baloy has accepted, he wouldn't know the internal working processes, would be given to him. And so when I was reading from the founding affidavit, and I mentioned the answering affidavit that came on the 24th, that was the day before the ruling was originally sought. And if the commission in its answering affidavit simply said, we'll give you the confidentiality pending the determination of the in-camera, then that would have cleared the path to file on the 27th. And so those are the facts about what came before the commission, and we can't, with all due respect in assessing reasonableness, determine the unreasonableness or the alleged unreasonableness of my client's conduct without those important factual features. Can I just say one more thing, Commissioner Baloy, and then I must make my third concluding remark in response to my learned friend, Ms. Hassan. On my client doesn't rely on threats in the public domain. My client relies, and that's what I understood Commissioner Baloy to have said about things in the public domain. If I misunderstood that.
Yeah, no, you misunderstood
okay.
me. Yes, I wasn't saying he relies on threats in the public, made to him in the public domain. Then, I was saying there is nothing in the public domain that finds
the breach.
Founds,
yes,
yeah, absolutely.
Yes.
That's
now,
the point
then we're ad idem. Then I don't have to say anything further. I understand what you were saying, Commissioner Baloy. Thank you. And then, lastly, in respect of the issue of the threats, I think it's also just important to say it out loud and on the record that 2 witnesses that have come before this commission have been killed. One allegedly killed themselves by means of suicide, but did so after there was an attempt on their lives, and the other was apparently killed potentially or allegedly in relation to what they may not or may not have done here. And all I would say in conclusion, in reminding the commission of that, is that your job and mandate is about serious issues that go to the heart of the criminal justice system and potential abuse of political connections, criminal connections, and political power, which threatens a huge many deal of interests of people. And where witnesses are dying after coming to the commission and giving evidence, it's surely not unreasonable in those circumstances that my client uses whatever procedural remedies are available to him to try and get relief from this commission, to protect him in some way, to make sure he's not subject to the same kind of treatment which is evidenced in his founding affidavit. Thank you, Chair.
Mr. Permit, I don't want to leave it uncorrected that the person who committed suicide testified before this commission. That person was never a witness before this commission.
I apologize.
So I don't want it to be left that way in the public
I
record,
apologize.
because factually
I spoke then subject to being told the incorrect thing. I apologize then. And I withdraw that to the extent I need to.
That actually deals with part of my preliminary point.
Mr. Premier, you're going to go into the merits, and maybe just you'll deal with this in the merits. I don't want you to deal with it now, so I can either, in advance of you arguing it, just tell you what my concern is, and then you will deal with it when you argue, and then we can raise questions as you go along. If you look at prayer 3 and 4 of your notice of motion, read with your Schedule A. The effect of it is that the Commission's investigation team must not have access to these documents. The Commission's head of security must not hear this evidence, must not have access to these documents. Now that is problematic because that is the work of the Commission. There is no way you can have a prayer. And our researchers, there's no way you can have a prayer that says the very evidence that's going to be led, your investigator must not hear or know about it. Because their job is to investigate everything that is presented and provide the Commission with facts. So the prayers are problematic, and I will just give you an example with prayer 3. We have, for example, a Mr. Brown Mokgotsi still coming to finish his evidence. If your client, either in his statement or in his evidence, says something that implicates Mr. Mokgotsi, or that Mr. Mokgotsi would like to respond to, Mr. Mokgotsi and his representatives must have access to that in the same way that your client had access to the evidence of Mr. Mokgotsi. And you would have said it's prejudicial to your client if they were not given the evidence and the statement. So it has to work both ways. If your client mentions any person and gives evidence against them, they would be entitled to that. So you cannot have a situation where all papers exchanged in relation to your client's evidence are not disclosed. It cannot just be this open-ended. And then you've had me on the Commission staff, especially, I mean, on matters of security, for example. The Commission's head of security, and I won't go into detail because those are sensitive matters.
And internal processes which we're not aware of, absolutely.
To assess what security arrangements have to be made, he needs to have access to all of this. So you cannot say he must not have access, because how else does he do his job? Do you follow me?
Yeah, no, I do.
Yeah.
Chair,
I'm sorry, Commissioner Kumalo said that that's for when you address the merits, and that think about it and deal with it when you address the merits. I think we've reached you were to...
that's why I was looking to you to give me direction whether it's now time to address the merits or not.
No. Let's adjourn for 5 or so minutes, give or take. We'll indicate when we are ready. So we are not strictly saying 5 minutes. It may be more. Let's adjourn.
Thank you.